5 seconds to go. Start. Mr. Malhotra also submits that as some of the information sought for pertains to third party, provisions of sections 11.1 and 19.4 of the RTI Act would be applicable to sections 11.1 and 19.4 of the RTI Act reproduced herein below. Third party information where a central public information officer or a state public information officer, as the case may be, intends to disclose any information or record or part thereof, a request made under this act which relates to or has been supplied by a third party and has been treated as confidential by that third party, the central public information officer or state public information officer, as the case may be, shall within 5 days from the receipt of the request give a written notice to such third party of the request and of the fact that the central public information officer or state public information officer, as the case may be, intends to disclose the information or record or part thereof and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed, and such submission of the third party shall be kept in view while taking a decision about disclosure of information, provided that, except in the case of trade or commercial secrets protected by law, disclosure may be allowed if the public interest in disclosure outweighs in importance any possible harm or injury to the interests of such third party. If the decision of the central public information officer or state public information officer, as the case may be, against which an appeal is preferred, relates to information of a third party, the Central Information Commission or State Information Commission, as the case may be, shall give a reasonable opportunity of being heard to that third party. On the other hand, Mr. Saini, learned counsel for the respondent, submits that it is difficult to comprehend that any public interest would be served by denying information to the respondent with regard to DPC proceedings, including the comparative grading statements pertaining to the recommended candidates, as also photocopy of respondents' ACR containing the remarks of the reporting and the reviewing officers, as well as accepting authority. Mr. Saini points out that the respondent himself is a government servant working in the same corporation and was considered by the selection committee for promotion in the said DPC proceedings. Hence, according to him, the respondent has a right to seek information regarding DPC proceeding, including the comparative grading statements pertaining to the recommended candidates. In support of his submission, Mr. Saini relies upon a judgment of the Supreme Court in Devdutt versus Union of India and others 2008 8 SCC 725, wherein it has been held as under. In the present case, we are developing the principles of natural justice by holding that fairness and transparency in public administration requires that all entries whether poor, fair, average, good, or very good, in the annual confidential report of a public servant, whether in civil, judicial, police, or any other state service except the military, must be communicated to him within a reasonable period so that he can make a representation for its upgradation. This, in our opinion, is the correct legal position, even though there may be no rule GO requiring communication of the entry, or even if there is a rule GO prohibiting it, because the principle of non-arbitrariness in state action, as envisaged by Article 14 of the Constitution, in our opinion, require such communication. Article 14 will override all rules or government orders. Stop.